Let us discuss law relating to minors agreement. The Indian Majority Act 1875 Section 3 provides a minor is a person who has not completed the age of 18 years. According to Indian Majority Act Section 3, minor is defined as any person under the age of 18 years. In the following cases, a person is said to be minor if he does not complete the age of 21 years. That means here minority will continue up to age of 21 years. Number one, any person under the Guardian and Wards Act 1890. Number two, any person who comes under superintendence of law or legal representative, his age will continue up to 21 years. Relating to property, the age is, he will be considered to be minor up to age of 21 years. Law governing minors agreement. Rule 1. Judges are the counselors, jury is the servant, law is the guardian of minor. Rule 2 is that in case minor entered into a contract which is unlawful, illegal, immoral, he is also prosecutable and punishable under the relevant act. Let us discuss law relating to minor in detail. First rule, an agreement with minor is void ab initio. Void ab initio means void from its beginning, void from its inception. This is a Latin term that means there is no agreement. Today an agreement with or by a minor is void and inoperative ab initio. Means from its beginning it is void. It is considered as there is no agreement. It is devoid of any legal right and obligation, which does not create any legal right and obligation is known as void agreement. Formally, the position was not clear. This issue came up in case of Mohori Bibi versus Dharmodas Ghose case. Earlier, it was not clear that whether an agreement with minor is void or voidable. Under English law, it is voidable, but the position was not clear in India. So this issue was settled in case of Mohori Bibi versus Dharmodas Ghose. In the above case, the Privy Council for the first time affirmed that minor's agreement is void and not enforceable in court of law. The fact of the case, in this case, a minor mortgages his house in favor of a money lender to secure a loan of rupees 20,000. Actually, he wanted to take some loan and therefore a minor he mortgage. Mortgage means to keep the property in the custody of other person for the purpose of security, for the purpose of security of loan. So this is known as mortgage. So in this case, a minor he mortgages his house in favor of a money lender to secure a loan of rupees 20,000, out of which the mortgagee, that is the money lender, paid the minor a sum of rupees 8,000 as an advance. Subsequently, the minor, he wanted to set aside this mortgage agreement. So subsequently, the minor sued for setting aside. Setting aside means for cancellation. Setting aside the mortgage, stating that he was under age when he executed the mortgage. It was held that the mortgage was void and therefore it was cancelled. Further, the money lender's request for the payment of the amount advance, that was rupees 8,000 to the minor as a part of the consideration for the mortgage, was also not accepted. Actually here money lender, he wanted to get recover or get back the loan which he had advanced to minor. But here the court said that refunding rupees 8,000 means enforcing the contract against the minor, and therefore no question of refund of money arose. The main reason for holding a minor's agreement void is that where an agreement by a minor involves a promise on his part or his promise is necessary part of the agreement, it is void because a minor is incapable of giving a promise. Imposing a legal obligation upon him would be injustice because he is a minor. He is not physically or mentally take decision whether what will be the effect of contract, and therefore minor's agreement is void ab initio. Second legal rule, minor can be a promisee or a beneficiary. So he can be a promisee or beneficiary. Inadequacy of a minor to enter into a contract means incapacity to bind himself by a contract. There is nothing which deprives a minor from becoming a beneficiary. He can always take the benefit out of the contract. Illustration, MH17 agreed to purchase a second-hand scooter for rupees 5,000 from B. He paid rupees 200 as an advance and agreed to pay the balance the next day and collect the scooter. When he came with the money next day, S told him that he had changed his mind and offered to return the advance. So here in this case, B cannot avoid the contract, though M may if he likes. Third rule, as to minor's agreement, no estoppel against minor. Section 115 of Indian Evidence Act lays down the law of estoppel. According to this rule, contained in Section 115 Indian Evidence Act, if you make a statement today which misleads another person, you are not allowed to deny the statement tomorrow. So when the question of your liability arises, in Vaikuntarama Pillai versus Authimoolam Chettiar. In this case, Madras High Court has held that as there is a clear statutory provision that a minor being incompetent to contract is incapable of incurring any liability for any debt. The law of estoppels cannot overrule this provision to make him liable. From the various decisions of the different high courts, we find that the consensus is that the law of estoppel does not apply against a minor. He is allowed to plead minority as a defense to avoid liability under an act, even though at the time of making an agreement, he falsely stated that he has attained the age of majority. Number 4 rule, restitution or compensation. So no restitution against minor. A minor cannot, in a suit to avoid a contract which is void, be compelled to compensate for or refund any benefit which he has received under such contract. Section 64 and Section 65 of Act do not apply to such cases, but equity requires a minor who seeks to avoid a contract which he induces the opposite party to enter with him by fraudulent representation as to his age to return, that is to restore the consideration which he has received in it. Fraudulent representation by a minor and its effect. So if an infant, that is minor, obtains property or goods by misrepresenting his age, he cannot be compelled to restore it, but only so long as the same is traceable in his possession that can be restored. This is known as the equitable doctrine of restitution, where the minor has sold the goods or converted them, he cannot be made to repay the value of goods because that would amount to enforcing a void contract against the minor, and therefore only the goods which are in possession that can be recovered. Number 5, no ratification. That is, his agreement cannot be ratified by him on attaining the age of majority. Ratification means subsequent acceptance, approval, sanction, or confirmation. Because here the ratification relates back to the date when an agreement was entered into. A minor on attaining majority cannot ratify, that he cannot give acceptance or approval to an agreement entered into while he was a minor. The reason is that ratification relates back to the date of making of the contract, and therefore a contract which was void at the time when it was entered into cannot be made valid by subsequent ratification. Since minor's agreement is void ab initio, it cannot be validated by any subsequent action. Hence, a promise by a person on attaining majority to repay money lent and advanced to him during minority cannot be enforced, as the consideration given during minority is no consideration at all. Every contracts need a separate consideration, and consideration which passed under the earlier contract cannot be imported into the contract which the minor entered on attainment of majority. So every contract needs a separate consideration, and consideration which passed under earlier contract cannot be imported into contract which the minor entered on attaining majority. Number 6 rule, minor and partnership. Minor as a partner. Minorship arises, partnership arises out of a contract. So, the essential of partnership is an agreement. It is therefore necessary that the parties to contract or partnership should be competent to contract. So, here there should be a partnership between the competent persons. A minor being incompetent to contract, he cannot become a partner. If a minor is made a full-fledged partner along with the other major partners, the agreement would be void and the deed containing their contract will be unenforceable even as between the other major partners. But he may be admitted to the benefit of already existing partnership with the consent of all the existing partners. Here, if already a partnership is between A and B, between the competent person already existing, in that case, a C can be admitted, C, a minor, can be admitted to the benefit of partnership. For this, prerequisite condition is that already existing partnership should be there. Then and then only he can be admitted to the benefit of partnership. Number 7, minor and agency. Minor as an agent. According to section 183, principal should be competent to contract. So a minor is incompetent to act as a principal. But according to section 184, agent need not be competent to contract, because here the contract takes place between the principal and the customer, and here a agent is a link between the principal and the customer. So it does not affect the validity of the contract. So he being a minor, uh, agent being a minor does not affect the validity of the contract. So minor can act as an agent. Number 8. Position of minor's guardian. And an agreement by a minor is void, but an agreement by his guardian on his behalf is valid, provided the obligation undertaken are within the powers of guardian. The guardian can function only within the doctrine of legal necessity or benefit, where contracting party is a minor represented by a guardian, and the contract is clearly for the benefit of a minor and was made at the request of the guardian for the benefit of minor, it binds the minor. However, the minor personally incurs no contractual obligation. In such cases, moreover, a minor may not be answerable for the fraud of his guardian. Number 9. No specific performance of contract. Here, against minor, there can be no specific performance of contract. Number 10 rule is that claim for necessaries. This is being an exception. Liability for necessaries, section 68 of the Indian Contract Act 1872. If every contract of a minor is void, minor might find himself in difficulties, for no one might lend him money. So, the law has consistently held that contracts by minors are valid if it is for necessaries. General rule, already we have discussed that an agreement with minor is void. But if it is a claim for necessary, such agreements are valid. The Privy Council pointed out in Mohori Bibi's case that under section 68, any person would be entitled to reimbursement out of the minor's estate for necessaries supplied to him or to his family. A minor is liable to pay out of his estate or out of his property for necessaries supplied to him or to anyone whom the minor is bound to support. The relief contemplated under section 68 is not dependent on any contract. In case of Inman versus Nash versus Inman, it was observed as follows. The basis of the action is hardly contract. Its real foundation is an obligation which the law imposes on the infant, that is, on the minor, to make a fair payment in respect of needs satisfied. The term necessaries is not confined to goods. It can include other things such as teaching, education, medical, clothes, residence, funeral expenses of parents, marriage expenses of sisters of the minor, and legal advice, etc. An article, therefore, is a necessary or not depending upon the status and the social position of the minor. Only the property of minor is liable. The minor is not personally liable. Even for necessaries, here he will not be personally liable, but here his property only will be held liable. So, minor is held liable for necessaries under the principle of equity. The claim arises not out of contract but out of what are called quasi-contracts, that is, certain relations resembling those created by contract, or that is known as quasi-contract, or the relations which resembling those created by contract. Again, it is only the property of a minor which is liable for meeting the liabilities arising out of such contracts. He is not personally liable. The law has provided this exception intentionally because if it were not so, it would be impossible for minors even to live. No one could have helped him, and therefore claim for necessaries are valid. In this case, in case of Nash versus Inman, a minor, he bought 11 fancy waistcoats from Nash. He was at that time adequately provided with coats. So it was held that the waistcoats were not necessaries and Inman was not liable to pay for any of them. It would have been necessaries. In that case, he could have entitled to recover. Legal rules relating to minor's agreement. In short, an agreement with minor is void ab initio, and on this point already we have discussed Mohori Bibi versus Dharmodas Ghose case. Second, minor can be a promisee. A minor, number 3, minor cannot ratify his agreement on attaining the age of minority. Number 4, restitution or compensation. So, no restitution or compensation against minor. Number 5, minor as a partner, minor as an agent, no estoppel against minor. He can always plead minority. He can enter into contract for his necessaries under section 68 that already we have discussed. On behalf of minor, his parents, guardian or any person can enter into a contract. So here I have completed law relating to minors agreement. Thank you.